Viewers, welcome to the Personal Injury Law Show. Viewers, this is the only show of its kind in Australia. We're the first people to engage in a show dealing with topics that are relevant and pertinent to you, the viewers. And we also try and enlighten the viewer and explain their rights in various issues that deal with your day-to-day activities. So stay tuned for the show. My name's Tony Carbone. I'm a lawyer of over 25 years' experience. With me tonight, I've got another very senior lawyer in a law firm, a partner, John Karantzis.
Hi, Tony. Hi, viewers.
And also a former lawyer come marketing superstar, Vivian Ryan.
Thanks, Tony. I don't know about that. Hi, viewers. Hi, John.
Hi, Viv.
Tonight, viewers, we've got a very interesting topic about surveillance, how it impacts on you, your claims, and your personal lives. But by surveillance, I'm not just talking about cameras. I'm talking about Facebook and also people spying through your computers and emails. So please stay tuned. It's going to be a very riveting and fascinating episode.
However, before we get to that, Tony, what's in the news?
John, there's been a lot of stories in the news, and Viv, this one is so fascinating. This fellow who was asked to wear a wig working for Virgin Airlines, they finally sacked him. Give us the facts, Viv.
It's really an interesting matter whereby a flight attendant was asked repeatedly over a period of time to cut his hair, and he produced a doctor's certificate to say that actually he had a medical condition and was required as part of his treatment to keep his hair at length. Ultimately, over time, it's actually a Virgin Airlines that ultimately sacked him for non-compliance with their professional standards.
And he's issued court proceedings in the Fair Work Commission, Tony.
John, can I go back a bit? I mean, this issue about a religious thing, listen to this. Religious reasons associated with the 10th anniversary of his mother's death.
I mean, look,
so it was a pretty pertinent, very, very
it's heartfelt
occasion, isn't it?
Absolutely.
Growing your hair can be very heartfelt, Tony.
Yeah, it can be heartfelt for a lot of people, John.
Yeah, or John. I mean, you should be the one standing up for this.
Tony,
He's not exactly sure.
Tony, I get asked quite a bit to cut my hair, and it's a very personal thing.
I think there's going to be an appeal lodged too, so we'll see what happens with this.
I reckon
matter.
he's going to win his appeal.
Yeah.
Bottom line, he's got genuine reasons. The loss of his mother, for some reason, it gives him comfort to have the longer hair. I would have thought that in those circumstances that
that's reasonable.
highly likely that an appeal court will...
And it comes under the general discrimination provisions, doesn't it, Tony?
Exactly.
I mean, though, the only thing it does call to question, and again, it's just along the lines of privacy and compliance with, the law. To what extent then, are companies able to enforce their own standards of behaviour as well? I mean, this is...
Well, that's where you've got the interaction of policies and behaviours and health situations. So I think the person's health's got to prevail.
What about the passenger's health in this circumstance? Certainly, they need to maintain a level of OH&S too, because they'll be serving food, etc., etc. So...
Yeah, exactly. And it just seems, Tony, time and time again, we're getting these medical conditions that we've literally never heard of.
Yeah, but if a doctor comes up with a condition, they can test it, John.
Of course.
There's other doctors out there that can, make a decision on whether it exists.
I guess the question is, just because you've got a psychological condition regarding what you want, well, does that still give you rights?
I think this is something we should do in a topic, a whole episode, because it's so important.
Oh, yes.
So we'll keep moving. Look, there's a very tragic, another teen's drowned on the Gold Coast surfing after going out partying. What's the facts of this one, Viv?
Well, unfortunately, this is the fourth time that a lifesaver has died during the course of a competition. So what was happening here was a lifesaver was actually participating in a surfing competition, and he's gone under and he hasn't resurfaced. There is some discussion around whether or not he had a prior medical situation that there's some allusion to the fact that he had suffered some sort of chest pain prior to the competition. But I guess the question here is, to what extent then is the surfing club liable? If this is the fourth one of its kind, I think that there was some information or some direction given that people should be wearing in these circumstances life buoyancy vests to prevent this sort of thing from happening. So then what right to compensation do this family have?
At the same time, Viv, we're talking about a life-saving competition. Now, it's going to be in the surf. They are dangerous conditions. Everyone knows that. Everyone goes in there willingly. No one's forcing
But they're
any
young,
swimmers.
John. They are young.
Well, then maybe it shouldn't occur, Tony. You can't have
the
it one or the
competing
other.
interests are you either make it safe or just cancel the event.
But how can you make it safe? Surf is the surf.
I still think a life jacket would have worked.
A life
Or
jacket.
a vest.
I mean, this gentleman was 17 years old. So then do we discuss, to what extent is it then the parents' responsibility to ensure that they're wearing the life vests? I mean, because they're not really legally considered an adult as yet.
Look, we don't want to become, literally, again, the nanny state.
I
But at the
understand
same time, we do have to protect our young.
Oh, look, I take View's point on this one. If I got my kid out there and, dangerous surf, and I prefer to be err on the side of caution.
If it was dangerous surf, Tony, they wouldn't be out there.
But also,
They've done it before.
But also,
How many
exactly,
people-
they have
yeah,
actually.
yeah,
They've
more
had
than once.
competitions in really dangerous surf.
Last year, I think a couple of very senior people were in trouble.
Well, that's where the organisation becomes liable.
I got this really bizarre one. This Carlton fan, John, takes a shot with double barrels at a Collingwood supporter.
I would have thought that's fair enough, Tony, don't you?
No, this is a Finnegan gun. And it gets better.
Double-barrelled shotgun.
But I mean, you would have thought that the guy, when he asked him, who do you follow? The guy's in a Carlton jumper with a double-barrel shotgun. You would have said, bloody Carlton, all the way through.
But look, I think the bizarre circumstances of these case was that these were people coming home from a match. It happened a ways away from the MCG, was in a place in Reservoir. And, this guy was shot in his car.
Yeah,
So, unfortunately, the person who allegedly shot this Collingwood supporter had been on an ice bender for 3 days.
Oh.
So, of course, then he used the defence of some psychosis. But, then...
Yeah, but what's he doing in the street? I mean, the guy's psychosis. He's obviously off his tree. There's no doubt about it.
Well, that's right. But then I think to myself, at what point is there some sort of responsibility with all these people taking all sorts of drugs? I mean, the hospitals are in dire straits as a consequence of ice and all of these psychotic...
How do you get his hands on a shotgun? That's what I'd like to know.
Double-barrel one too.
Yeah, how do you get his hands on a shotgun?
A lot of people have one sitting under their bed, Tony.
Is it easy to get shotguns these days? Or
I
do
think-
you need a licence for that?
Yes.
You absolutely
course you
need
do,
licences for that. But I think that this is absolutely tragic, regardless of what football team you support. And everyone just has to be completely safe. I mean, you have to really be mindful of the strangers you meet on the street or on the road.
Can I just say this? You guys are so heated on these topics today that we got through very few stories. Viewers, we've got to go to a sponsors break. So please stay tuned because we've got this very interesting topic of surveillance with Professor Zifcak. He has got plenty to say, so stay tuned. Jules, welcome back to the show. As stated before the break, we've got a very interesting topic on surveillance and how it affects you. And tonight we've got a very special guest who's been on before, Professor Spencer Zifcak. Now, Professor, tell us a little bit about how surveillance impacts on injured people.
Well, surveillance is becoming immensely prevalent in every aspect of society, and not least in the workplace. Employers are seeking greater and greater permission to keep people under surveillance, to regulate the way in which they work, to track people's emails. in some cases to film people when they come in and leave work. And even in some workplaces, they're setting up cameras in employees' personal desktop computers so that they have a record of the person's attendance and, in fact, everything that they do during the course of a working day. So this is becoming an immensely serious problem.
We've got a struggle between the rights of the employer to really know what's going on in his workplace,
Yeah.
but then the rights of the individual to literally, have your own privacy.
That's exactly right, and that's why we need a new set of rules, and I think we need a regulator to make sure that employers do not engage in unreasonable invasion of their employees' privacy.
John, the professor raised a very interesting point. We know surveillance to be, they're following you with cameras.
Yes.
But he said that spying on emails and looking at your desktop computers, setting up cameras on that. So it's a bit more than just surveillance by camera, isn't it, John?
Well, traditionally, in personal injury litigation, Tony, in transport accident cases, work cover cases, the authority, the Victorian Work Cover Authority or the Transport Accident Commission will hire investigators to follow the injured claimant around, to videotape them going to their medical appointments, leaving their medical appointments, going back home, whether or not they're using a cane when they're going to the medical appointments, and other times when they're shopping, as in to catch the claimant out as to what he says are his physical limitations and disabilities.
To find inconsistencies.
And what the reality is, exactly.
All right. Can I just say this? Viewers, what's important is that when you're dealing with surveillance, it picks up work cover claims, public liability, medical negligence, transport accidents, all sorts of claims. Superannuation's another big one these days. So you've got to be very, very cautious. Professor, at the moment, the state of the law in Victoria is in a state of flux, isn't it?
Yes, it is. Yep.
There's no protection to the worker because unlike other jurisdictions around Australia, even if there is surveillance of an individual person that may impact on their claim, the defendant, that is the employer and or defendant, is not obliged by law to hand over the surveillance material before the hearing. Is that correct?
That's correct. That's the product of a case in the Victorian Supreme Court in 2004. And here's the reason. The reason is that there's a clash of legal principles here. On the one hand, you've got the principles of natural justice, which mean that a worker is entitled, if involved in litigation, to see all the evidence that's going to be presented against him or her. And the principle on the other side is that if a surveillance video has been specifically prepared for the purpose of litigation, it falls under the general rubric of legal professional privilege. And so the Supreme Court has had to make a decision about whether it favours the retention of legal professional privilege or whether, according to the rules of natural justice, procedural fairness, a worker is entitled, if involved in litigation, to see all of the evidence that will be presented against them so that they can make appropriate justifications and defence of the actions that they've taken.
John, that's the case of State of Victoria and Davies.
Yes,
Very
exactly.
important Supreme Court case. But the thing that really astounds me is this. The courts have always wanted the parties to exchange materials before so that everyone lays their cards on the table. Is that correct?
We're required to, yes.
Now, you as a trial lawyer would know that if you've got a video of your client that is absolutely going to blow your case out of the water, you'd prefer to see it in advance because you wouldn't waste your time, your client's time and resources,
Exactly.
nor the court's time and resources. Is that correct?
Exactly, Tony. And we say this to work cover and to the TAC time and time again. If you have video surveillance that is at odds with what our client is saying, give it to us, we'll take it to our client and we'll do the right thing. Simple as
Professor,
that.
it seems to be a trust issue here. It sounds to me that either the politicians or the defendants don't trust the plaintiff lawyers to obtain this information that may destroy their client's claim and use it appropriately.
Look, I think the point that's just been made is a perfectly valid one. I mean, why would you bother putting your client and yourselves to the cost and expense and stress of engaging in legal proceedings when, if you get the evidence that was required immediately before the case, the matter could be settled almost immediately.
Exactly.
So I think it's a really, really good point, and it's a point that's not effectively understood yet, I think either within the legal profession more widely and more particularly amongst certain judges that hear cases of this kind.
Professor, the Transport Accident Commission has come one step forward. Under the TAC protocols, any video surveillance that's obtained within the protocol period and before the conference of the actual claim, as in before the hearing, that must be exchanged under protocols. So they have taken one step forward. However, WorkCover, the Victorian WorkCover Authority, have made it clear, Tony, that they will not abide by those protocols.
Abundantly clear.
They want to ambush the worker in the stand whilst he's giving evidence.
Well, there's another facet of this too, and that is that the decision in the case of Davies that you're talking about wouldn't have been the same if we had county court rules with respect to disclosure that they do in some other states. So really the way around this is for the county court to be approached and if necessary the government to pass appropriate legislation which will require all of the evidence to be put on the table, including video footage, even if that results in some marginally negative impact on legal professional privilege. But you know, what's important here, to me at least, is the justice in the individual case and legal professional privilege to a minimal extent can be compromised in order to pursue that.
This raises a lot of interesting points. Viewers, we've got to go to a sponsors break. After the break, we're going to look at the interaction of the Bill of Rights and also whether the denial of natural justice can be protected by using the Bill of Rights. So stay tuned. Welcome back to the show. Before the break, I raised the issue of the Charter of Human Rights in Victoria and its interaction with this issue about surveillance, denial of natural justice, and whether we should maintain privilege of these surveillance videos. Now, we're very fortunate to have the Professor on board tonight. Professor, do you believe that a Victorian law firm should challenge the failure to exchange a surveillance video based on that Charter of Human Rights for a denial of natural justice?
I think it would make a very interesting and important test case under the Charter of Human Rights and Responsibilities in Victoria. I mean, what we're talking about here is the possibility of a miscarriage of the principle of fair trial. Now, the Charter of Human Rights and Responsibilities in Victoria makes it quite explicit that every person in Victoria has a right to fair trial. And critical to a right to fair trial is for the person to be accorded what we call procedural fairness. In this case, I think there is significant doubt that if a video surveillance tape is not provided to the other side in a proceeding like this, the human right to fair trial may be compromised.
Just on that point, Professor, John, the Professor's saying that if you've got the videotape in your hands, number one, you can bring in your client and say, right, watch the tape and give us your instructions. Two, you might be able to put that tape to various witnesses, in particular medical practitioners, to see if you can put it in a context or if there can be any explanation as to the person's behaviours as seen on the video. Now, so you've got that competing thing of denial of natural justice, which is procedural fairness, as opposed to the privilege of getting someone by surprise. You put them in the box, you don't know what you're going to see on the video, and then bang, you spring it on them.
Well, that's the issue. WorkCover don't want to give you, the worker, the opportunity to fix your case up.
But is it a question of fixing your case up, John?
Well, they don't want you to take this videotape to your doctors and then get an explanation. You're fixing your case up. You're doing something that really, they don't want you to do.
Okay, why isn't an appeal point based on what the professor said that you've been denied procedural fairness because you cannot put your best foot forward because you haven't been given that opportunity?
You haven't been afforded the opportunity to view the videotapes and come up with your response.
You've been ambushed.
You've been ambushed. At the same time, the other issue is, will this the question of procedural fairness pierce the issue and the question of privilege?
That's exactly the point. So you've got competing interests here. So it's not absolutely straightforward.
And the courts have been very loath to touch privilege, haven't they, Tony?
They have up until now. Look, I think this is a perfect opportunity for the viewers to send us some Twitter and Facebook comments. This is something where you can almost vote on whether we should have the opportunity to view the videos or whether we should maintain privilege. I think the rights of the individual far outweigh the rights of an insurance company that's got a lot of money, Professor.
And Tony, things have changed since 2004. In 2004, there was no Victorian Charter of Human Rights.
Exactly.
So we've got that glaring in our way now, which is a good thing. So look, it really comes down to the right plaintiff lawyer challenging the law, because as it stands, viewers, any video surveillance is admissible in a court of law during a court proceeding, and it does not have to be exchanged. You can be ambushed.
But John, it goes beyond that, and this I want to raise this. Facebook. A lot of people go onto Facebook and they embellish situations. Now, a lot of these people could have back injuries, shoulder injuries, because they're on holidays and they want to put on a brave face for their friends. You know, the extreme case is bungee jumping. All these Facebook events do destroy claims.
Sure.
Well, Facebook is admissible in court. We've been involved in cases, haven't we, Tony, where either the TAC or WorkCover have subpoenaed the Facebook photos. They've actually befriended the worker, and under an alias. In that case, the judge found it not to be admissible because of that it was an alias. Yeah. It was almost akin to entrapment. But at the same time, viewers and workers and people making personal injury claims, you have to be aware. Anything you put on Facebook, it's a public document. It's available to everyone. It will be admissible in a court of law. Professor,
do you believe that Facebook should be permitted in a court of law where the individual doesn't grant permission? They don't specifically go out of their way to grant permission. They might invite someone by mistake that picks up the information that's on the Facebook and website.
Well, look, Facebook is now so prevalent that it seems to me that people should become exceptionally aware that what they put on their Facebook sites may at some stage or another, in relation to some case or another or some circumstance or another, be used against them in legal proceedings or in social interactions and so on. So the advice here is not really legal advice. The advice is for people who use Facebook to know that it presents a perfect opportunity for people to invade individual privacy. And Facebook itself says, we don't guarantee the confidentiality and the privacy of the material that goes up on Facebook. And they've been caught out many times in that respect.
Exactly.
So really, it's a matter for wide public awareness, and people should take their own steps to make sure that nothing gets on. Same with the email. You never write an email except on the possibility that it will appear on the front page of the paper tomorrow. Same with Facebook. So, I mean, it's just clear public awareness.
Viewers, the other thing too is with this Facebook and whatever you post on there, it could impact on future careers, because a lot of the people that are posting there are very young and they're at university, and some of the things they come up with is just bizarre. But one day they're going to have a serious side to themselves, and it could be that a future employer might somehow stumble on some of these things that are being posted that could impact on the possibility of them getting a job. Do you agree, John?
Well, Tony, as you and I both know, whenever we want to know something about someone, you'll input their name in a Google search.
Okay, it's true.
And see what comes up.
Yeah. Professor, we've come to that part of the show. We've got to wrap it up. Is there anything else you want to add? Because this is a very big topic. And
Yeah. Let me just read you a quote from the Supreme Court decision, which just summarises this in one sentence. The court said that legal professional privilege, lawyer's privilege, is a general principle of the common law of great importance. But then here's the critical bit, which is not to be sacrificed, even to promote the search for justice and truth in the individual case.
it's almost outrageous, isn't it?
That sentence ought to be up before the courts under the Charter of Human Rights.
Exactly. No, we'll highlight that because it's almost an outrageous statement because, in effect, you're violating a person's right
Well,
to
what you're
natural
saying,
justice.
what they're effectively admitting is that legal professional privilege may trump the right to fair trial.
Which is
But
bizarre.
that's not, in my view, in any way appropriate, and it ought to be challenged.
Professor, thanks for coming on the show tonight. I really appreciate it. John, anything else you'd like to add?
No, thank you, viewers. Take care, be safe, and again, as I've stated earlier, video surveillance is admissible at any time, at any place.
Viewers, thanks for watching the show tonight. I want to thank John and the Professor for coming on board. Stay tuned for future episodes. Go back to our past episodes, which are also pertinent to tonight's topic. Give us your Facebook and Twitter comments, and always remember to stay safe.